O'Connor, and let me thank the witnesses for what I think has been a very informative discussion. Let me begin with Professor Bridey. The Supreme Court, the 1975 decision, I believe it was written by Potter Stewart, 20th Century Music Corporation versus Aiken, made this statement: the immediate effect of our copyright law is to secure a fair return for an author's creative labor. But the ultimate aim by this incentive is to stimulate artistic creativity for the general good. Statement made by the Supreme Court about the underpinnings of our copyright law. Would you agree with the sentiment that was expressed by the court in this opinion?
I do very much agree with that. I think that it is very important to secure to creators a return on their investment so that they are incentivized to create more creative content for the public, but that ultimately the system is designed to deliver creative works to the public. And so I very much agree with that statement, and I think that the DMCA has really worked a good balance to try to help that policy objective to thrive in the digital environment.
Now, I agree with your observation that the DMCA should be or is correctly about promoting a balance between sound copyright policy on the one hand and sound innovation policy on the other. And in the context of sound innovation policy, is it fair to say that a robust safe harbor provision is important to allowing for innovation to continue to flourish in the digital age?
I think it's crucial. I think there's no question.
Now, as it relates to the applicability of the safe harbor provision to Internet companies, it's my understanding that if there is either actual knowledge or red flag knowledge of infringement activity, then that safe harbor provision is no longer applicable, correct?
That's right. It puts them outside the safe harbor.
Now, in the context of how courts have defined red flag knowledge, could you provide for us some clarity as to what the current state of the law is in this area?
Sure. I think we're going to get some more guidance in not very long from the Second Circuit on this issue, because the Viacom versus YouTube case is on appeal for the second time in the Second Circuit. And one of the issues that is live before the circuit now is what the interaction is between red flag knowledge and this doctrine of willful blindness about which Professor O'Connor spoke earlier. And so I think that most of the courts that have decided this issue have said that red flag knowledge is knowledge of facts or circumstances from which infringing activity is apparent, and that the knowledge in question can't just be generalized knowledge. It has to be red flag knowledge of specific instances of infringement on a service provider's system.
Thanks. Now, Professor O'Connor, in your view, have the courts provided either sufficient guidance as it relates to red flag knowledge, and as they have defined this area, has it been sufficiently robust to make this particular provision meaningful?
Thank you, Representative Jeffries. Respectfully, I don't think they have adequately taken care of the doctrine. I think that, as Professor Bridey is saying, that they're really limiting it. Well, she might not be saying that, but to where you have actual knowledge of that particular work. And so it gets narrowed and narrowed so that even if you have a sense that there's lots of infringement going on, you can still essentially turn a blind eye to it. And I don't think that was the intent. So I do, again, suggest respectfully that Congress could consider setting the policy on what willful blindness should be. If you're aware there's infringement going on in your site, you should then take some steps to mitigate it.
I would note that in other areas of the law, you have a commonly understood principle of either actual knowledge or constructive knowledge. The term constructive knowledge doesn't appear in the DMCA, but presumably that is part of what Congress had intended in terms of bringing this particular provision to life. But Ms. Oyama, I'd also note that perhaps there's a reasonable argument that the Internet context is different. In the fraud instance, for instance, constructive knowledge requires a duty of inquiry, which it appears the DMCA explicitly did not impose in this particular instance. What are your views as it relates to whether red flag knowledge should be more broadly defined?
I think actually the Internet context makes the requirement of knowledge of specific infringing acts even more important because of the diversity in the ecosystem and the different ways that creators are engaging with content. And so just because, imagine we even were able to say this is a song and this is all the places that it appears. Artists have very different standards on where they want it to appear, who they're authorizing, who's not allowed, who's allowed. And so that's why we need that cooperative process where they specifically tell us, this one's okay, this one's not okay, this one I didn't know about, but actually that's really cool, that one can stay up. I think you want to make sure that we're not giving the wrong incentives to online services and platforms to build and innovate in this space. And so if you narrow the safe harbors and you make it more risky for providers to be innovating in this space or building on their own above the law, filtering and monitoring and things like Content ID, you're going to make everybody very fearful that they're going to hit up against this legal liability. And so I think creating a very clear and certain platform that then allows people to experiment and build better systems so that all of the businesses can be licensing and earning revenue from the content is the right direction to go. You don't want to inject a lot of fear and confusion into the ecosystem, especially with small companies that are trying to get investment. They don't want to get sued out of existence. If you start to impute, more things of you might be taking actions and this would show you're willfully blind. No one understands what those standards are. They're very vague. That's going to be the wrong incentive because they're not going to be trying to fix these problems voluntarily.
And Mr. Chair, if I could just ask one brief follow-up question. At the beginning of my remarks, I referenced a Supreme Court decision that noted some principles, largely that can be boiled down to fair return and stimulating artistic creativity as underpinnings of our copyright law. Would you agree that those still remain, even in the internet context?
Absolutely.
And the value of the innovation economy,
Yeah.
Strong things for us to consider?
Yes, I think incentivizing creativity is the place that we should all be looking towards and kind of working backwards from in terms of policies that we would support. And it's an exciting time. There are more creators that are able to gain access to the tools of creation, to distribution, to monetization. These industries are changing, but I think that's an exciting thing. There's more creativity out there than ever before.
Thank you, Mr. Chair.
Well, Chair recognizes